Welcome to our deep dive in the English law of contract. This podcast takes you in some detail through problems that may spoil a contract. We discuss duress and undue influence, present the doctrine of frustration, and continue to examine misrepresentation and mistake. We cover all the basics one needs to understand in order to prepare for an undergraduate law exam or the solicitor's qualifying examination. Challenge yourself to stick till the very end and make some notes as you are getting along. If you are looking for explanations of particular concepts, use the chapters noted in this video to jump to the topic you need. This podcast was prepared by Dr. ioannis.glinavos with the use of AI tools. Get in touch with Ioannis, following the information on the video's description, to learn more about how this podcast was generated. The law of obligations has, as is well known, two main branches: that of voluntary agreements, contract, and that which concerns obligations that arise as a result of a duty of care owed, tort. Inherent in the first branch, contract, is the concept of consent. While, however, the concept of consensual bargaining is central to our understanding of contractual obligations, the courts have been reluctant to set aside contracts. This is especially the case when consent is affected by power differentials in contractual bargaining. For instance, it is difficult to set aside contracts between parties of unequal bargaining power solely on the basis of inequality. At the same time, however, courts will not allow the strong to push the weak to extract agreement and, in certain circumstances, courts will set aside apparent contracts. Law and equity develop different responses to the use of illegitimate pressure. Courts of equity would set aside a contract where one party had unduly influenced the other to enter into a transaction. Courts of common law were slower to develop a response to the use of illegitimate pressure but do now recognize, under the doctrine of duress, to render a contract voidable where one party has employed illegitimate pressure during the contractual process. Both duress and undue influence represent situations in which someone has not entered into a contract as a result of their own free will. Their choices have been interfered with in some way, which means that the decision to enter into an agreement has resulted from coercion. Proving that this has occurred, however, is usually difficult, as in some situations the pressure placed on one party by the other can be subtle, and therefore this is one area where presumptions are used as part of the legal arguments establishing a lack of free will. The outcome of successfully arguing that the free will of one party has been coerced is giving the coerced party the freedom to escape the contract, and therefore agreements in this area will be voidable at the discretion of the victim. We deal with these two key ways of addressing lack of propriety in contractual bargaining. We start with a discussion of the doctrine of duress, before moving on to a consideration of undue influence. A key assumption in all discussions on contractual negotiation is that any agreement is the result of a voluntary action of the parties. As mentioned at the beginning of the presentation, generally, courts are reluctant to set aside a contract between parties of unequal bargaining power solely on the basis of inequality. At the same time, however, courts will not allow the strong to push the weak to extract agreement. Who the weak party will be in the types of business contracts we are discussing here will obviously depend on the circumstances. For instance, a landlord will normally be in a stronger position than a tenant in a contract for a domestic tenancy, but the opposite may be true in the case of commercial premises where there may not be a wide range of alternate tenants. As an illustration, consider the frequent use of company voluntary arrangements, CVAs, a controversial form of insolvency being used by a growing number of struggling high street chains. These are employed to entice property owners to accept lower rents to help a tenant avoid financial collapse, and are seen by many landlords as attempts by tenants to avoid their rental obligations. Law and equity develop different responses to the use of illegitimate pressure. Courts of equity would set aside a contract where one party had unduly influenced the other to enter into a transaction. Courts of common law, under the doctrine of duress, can render a contract voidable where one party has employed illegitimate pressure during the contractual process. The law encompasses duress to goods and, more recently, economic duress. Duress renders the contract voidable, rather than void. The apparent consent of the victimized party is treated as revocable. They have the ability to affirm or not to affirm the contract. If they choose not to affirm the contract, it is void. See Universe Tankships of Monrovia v. International Transport Workers Federation, the Universe Sentinel, 1983, and Pow on v. Lao Yu Long, 1980. The effect of finding that duress renders a contract voidable has several important consequences. For example, the party subject to the duress must act promptly to set aside the contract, see North Ocean Shipping v. Hyundai Construction, 1979, and a third party can acquire good title to goods even though his vendor has acquired those goods pursuant to a contract which was brought about by duress. Initially, only duress to the person, a threat to the personal security of an individual, Barton v. Armstrong, 1976, was recognized as duress. Gradually, the law expanded to encompass duress to goods and, more recently, economic duress. There is even some support for the position that duress renders a contract void amongst the academic commentators, especially when duress is to the person. However, the prevailing view is that duress renders the contract voidable, rather than void. The apparent consent of the victimized party is treated as revocable. Duress to the person occurs when one party to a contract forces another to contract with them through threats of violence. Where a party enters into a contract for several reasons, of which the duress is only one reason, the contract is still voidable. See Barton v. Armstrong, 1976. Duress to goods may occur where one person threatens to destroy or take the goods of another unless a contract is entered into. Duress to goods was recognized in the case of the Ciboan and the Cibotra, 1976. Economic duress as such was recognized in Powon v. Lau Yu Long, 1980, and Universe Tankships of Monrovia v. International Transport Workers Federation, the Universe Sentinel, 1983. Economic duress occurs when one party uses its superior economic power to force the weaker party into an agreement. The main difficulty in this area is to draw a line between unacceptable commercial pressures, which amount to economic duress, and acceptable commercial pressures, which do not amount to economic duress. Duress exists when there is an illegitimate threat to perform an act unless the other party enters into a contract or varies an existing contract. Consent must be vitiated. Lord Hoffman in R.V. Attorney General for England and Wales, 2003, stated that the wrong of duress had two elements. First, pressure amounting to compulsion of the will of the victim, and, the second was the illegitimacy of the pressure. The difference between acceptable and unacceptable commercial pressures is explained in the speech of Lord Scarman in Powon v. Lau Yu Long, 1980. The following are used in determining whether or not there was a coercion of the will such as to vitiate consent. 1. Did the person who was allegedly coerced protest at the time? 2. Did this person have an alternative course of action open to him, such as an adequate legal remedy? 3. Was the person independently advised? 4. Did the person take steps to avoid the contract once they had entered it? See CTN Cash and Carry v. Gallagher, 1994. Let us consider these requirements in a bit more detail. In summary, a finding of economic duress will rest on proving three core elements: that 1. A threat was made; 2. The threat was illegitimate; 3. A contract was concluded, but the threat affected the decision-making of the party in the sense that they did not enter into the contract exercising free will. Explaining the threat. First of all, a threat needs to be made. Pressure arising from unfortunate circumstances is not enough. However, threatening to carry out an action that is perfectly lawful would not be seen as forming part of duress. For example, Williams v. Bailey, 1866, concerned a threat of being lawfully imprisoned. D&C Builders v. Rees, 1966, illustrates an illegitimate threat that resulted in the agreement to accept less. In Universe Tankships Inc. of Monrovia v. International Transport Workers Federation, the Universe Sentinel, 1983, a trade union refused to provide tugs to tow certain ships out of harbor unless certain payments were made to its welfare fund. Without the tugs, the vessels would not have been able to sail, and this resulted in the ship being effectively blacked, a term meaning that the trade union's members would not deal with it. They claimed that they were entitled to make such demands because they were protected by the Trade Union and Labor Relations Act 1974. They claimed that the money was extracted as part of a labor dispute, which was protected by the Act. The court held that the availability and eligibility of the welfare fund to employees was not connected to their terms and conditions. Therefore, the union's actions amounted to illegitimate pressure. However, it would be wrong to equate illegitimate with unlawful. In Al Nehayan v. Kent, 2018, the claimant claimed from the respondent amounts due under a promissory note and joint venture agreement. The respondent alleged that his consent to the agreement and the note was obtained by unfair means, including threats of physical violence and economic duress. Leggett L.J. restated the law on duress at quoting Times Travel, UK, Limited v. Pakistan International Airlines Corp., 2017, there can be no doubt that even a threat to commit what would otherwise be a perfectly lawful act may be improper if the threat is coupled with a demand which goes substantially beyond what is normal or legitimate in commercial arrangements. There is no reason the distinction between lawful and unlawful behavior should be decisive of whether the respondent can retain money or other benefits demanded from a claimant in a situation of extreme vulnerability. It is appropriate to take account of the legitimacy of the demand and to judge the propriety of the defendant's conduct by reference not simply to what is lawful but to basic minimum standards of acceptable behavior. In summary, therefore, a demand coupled with a threat to commit a lawful act will be regarded as illegitimate if I. The defendant has no reasonable grounds for making the demand, and b. The threat would not be considered by reasonable and honest people to be a proper means of reinforcing the demand. The doctrine of duress could be interpreted as being based not on lack of consent but on showing that a party's consent was obtained in circumstances which make it unjust to allow the other party to enforce the agreement. Therefore, that legal advice was taken or rational or independent judgment exercised in entering into a contract does not preclude a finding of duress. What is necessary is that the illegitimate pressure caused the claimant to enter into the contract. As to causation, a threat of violence causes a party to enter a contract if it is a reason for entering it. With economic duress, the but for test applies. It is not necessary that the claimant had no reasonable alternative to giving in to the illegitimate pressure. What is required is very strong evidence of whether the claimant was induced by the threat or other illegitimate pressure to enter into the contract. This is also a relevant factor in deciding whether use of pressure was illegitimate even though there is no illegality. Examining the contract, there has to be an effect seen as a result of the threat. If duress is about showing the will of one of the parties has been subverted in some way, there has to be a link between the decision to enter the contract and the threat made. In Barton v. Armstrong, 1976, a former chairman of a company threatened the managing director with death if he did not transfer his share of the company for a large sum of money. However, the argument in court to strike out the transaction for duress failed, because there was some evidence that the managing director believed this to be a good deal and, although he felt apprehensive about himself and his family's safety, this did not affect his judgment and so his decision to enter into the contract was one that involved his exercise of free will. It was therefore difficult to show that the threat had affected his decision-making such that it could be thought of as duress. Examining consent. The effect of duress is that it negates the will of the parties, but this is subject to some interpretation. Negating of consent does not have to be total, but can be satisfied if the alleged victim is required to choose between the lesser of two evils. In D&C Builders, 1966, case the creditor had a choice of either accepting the money and the revision to the agreement, or suing the other party for breach of contract. However, as the victim was in financial difficulty, they did not have the time or resources necessary to pursue a claim in the courts. Therefore, there was duress present, because it required them to choose under the constraints imposed by the threat. In order to find affected consent, therefore, we can look for situations where a party to a deal has no realistic choice. While the common law doctrine of duress is concerned with the procedure by which a contract was agreed, the equitable doctrine of undue influence is focused upon the relationship between the parties. Equity acts upon the conscience, and the equitable doctrine of undue influence operates where the people are in a relationship where one party relies upon the other. The court in Royal Bank of Scotland v. Ettridge, No. 2, 2001, described the doctrine as one of the grounds of relief developed by the courts of equity as a court of conscience. It is something that stops short of duress, as a specific threat made against the other party is not required. We could summarize the doctrine by saying that undue influence arises because of a subtle influence that another person has over the other party when one person occupies a position of power over the other party and can use that position to influence the other party to enter into a contractual agreement. The objective is to ensure that the influence of one person over another is not abused. In the past, courts divided undue influence into two categories: actual undue influence and presumed undue influence. Royal Bank of Scotland v. Ettridge re-explained what was meant by this division. In one instance, undue influence was presumed as a matter of law by reason of the type of relationship between the parties. In the other instance, undue influence would not be presumed by law, but it was open to a party to establish an evidentiary presumption of undue influence. Actual undue influence. In such cases, the claimant must prove that the wrongdoer actually exerted an undue influence upon the complainant to enter into the transaction in question. In these instances, the criteria are: 1. that the party to the transaction, or a person who induced a transaction for his benefit, had the capacity to influence the other party. 2. That he did influence the other party. 3. That the exercise of this influence was undue. 4. That it was because of this influence that the transaction was brought about. In a situation of actual undue influence, it is not necessary to show that the transaction was manifestly disadvantageous to the party subject to the undue influence. See Lloyds Bank v. Bundy, 1975. In CIBC Mortgages v. Pitt, 1993, a husband put pressure on his wife to agree to a £150,000 loan being taken out on the house they jointly owned in order to buy shares. The husband encountered problems with repayment of the loan after the stock market crash in the late 1980s, and the bank attempted to repossess the house in order to recover the amount of the loan. When the bank attempted repossession, the wife argued that she had only agreed to the loan because of the pressure that had been placed upon her by her husband. The undue influence in question came from a campaign of sustained pressure, rather than a particular threat. At trial, the court was satisfied that this course of conduct was such that amounted to actual evidence of undue influence. The campaign of sustained pressure overcame her initial objection to the purchase. Presumed undue influence. Here the claimant need not prove that there was actual undue influence. These situations, according to Lord Nichols in Royal Bank of Scotland v. Ettridge, No. 2, 2001, may arise in one of two ways. In the first case, the law makes a genuine presumption in relation to certain, defined types of relationships, such as doctor and patient, solicitor and client, trustee and beneficiary, religious advisor and disciple. Since the Ettridge, No. 2, case, a finding of the existence of one of these relationships places the parties in a protected situation where the presumption of influence cannot be rebutted. Merely the finding that the influence was undue is under consideration. To allow otherwise would call into question the validity of that relationship's presence, as they are said to be relationships that always conform to the same type. The burden of proof in establishing the presumption of influence lies with the party claiming undue influence. In the above situations, once that burden has been discharged, this presumption of influence is fixed and cannot be discharged. This is the consequence of the way in which the specially protected classes are now regarded in the wake of the Ettridge, No. 2, judgment. However, there are several categories that do not give rise to this automatic presumption but may fall into another category instead. This is because these are situations where it is possible to prove that there is a close relationship of trust and confidence, but it should not be automatically assumed from the existence of the relationship. These are husband and wife, banker and customer, employer and employee. By extension, one would also logically consider all marriages since the Marriage, Same-Sex Couples, Act 2013, as well as civil partners, cohabitees and anyone else in intimate personal relationships. See Future Loans Limited v. Julianne Porter and Daniel Luigi Gianquito, 2015. In these second-type cases, there is a shift in the evidential burden of proof from the complainant to the other party, to show that the transaction was made without improper influence. For this situation to arise, two elements are required. Firstly, that the complainant reposed trust and confidence in the other party, or the other party acquired ascendancy over the complainant. Secondly, that the transaction is not readily explicable other than as resulting from undue influence. In other words, the complainant may prove the de facto existence of a relationship under which the complainant generally reposed trust and confidence in the wrongdoer. The existence of such relationship raises the presumption of undue influence. See Barclays Bank v. O'Brien, 1994. The burden of proof then shifts to the alleged wrongdoer to disprove that they did not exercise undue influence, which is done by establishing that the complainant acted independently and understood his or her actions. In Annulment Funding County Limited v. Cowie, 2010, the Court of Appeal found that actual undue influence and evidence-based presumed undue influence could be considered as alternatives by the court. This case concerned a man who was declared bankrupt, but who had a beneficial interest in a house, jointly with his partner, the amount of which more than covered the amount of debt that had led to the bankruptcy. He engaged Annulment Funding, a company that specialized in annulling the bankruptcy of its clients by loaning them the amount required to pay off the creditors in bankruptcy in the form of a bridging loan. This is a short-term loan, used until the now discharged bankrupt client can obtain a mortgage on their property to pay back Annulment Funding Limited. In Mr. Cowie's case, the mortgage broker was unable to find a mortgage, and so Annulment Funding took action to recover the amount of the bridging loan by repossession and sale of the house that Mr. Cowie and his partner jointly owned. Mr. Cowie's partner argued that the agreement she had entered into regarding the bridging loan was subject to Mr. Cowie's undue influence and argued for a presumption to be set up of undue influence that would then need to be rebutted by annulment funding in order for them to be able to repossess the house. The court held that there was enough evidence to establish a case of actual influence and found on this basis. It also held that even where a party argues for a finding of presumed influence on the basis of evidence, the court is at liberty to find that actual influence had taken place on the basis of that evidence, and as there had not been enough evidence to demonstrate actual influence, presumed undue influence could be used as an alternative. How to avoid a presumption of undue influence? In the latter cases mentioned, again, the burden is upon the party claiming influence to establish a presumption. However, this is done through evidence of the relationship at hand, to demonstrate that trust and confidence exists. This therefore leads to a presumption that one party has influence over the other. This is where these cases are different from the automatic presumption ones discussed earlier. The burden here is reversed, and it is then up to the other party to rebut this presumption of influence. This can be done most effectively by showing that the other party was not in fact induced and entered into the agreement freely. So if you were accused of unduly influencing someone's decision to enter into a contract with you, the most effective way of rebutting the presumption that you have influence over them, such that they have trust and confidence in you, is to show that they made the decision independently, maybe through showing that they had independent advice. This would therefore demonstrate that the decision made was one that was a fully informed one, based upon independent advice and not solely upon the influence of the other party. You should note that the concept of manifest disadvantage is no longer useful in analyzing instances of undue influence. Lord Nichols in Ettridge, No. 2, commented that transactions of a more unusual nature, for example an unusually large gift, would call for further explanation. The actions of an employee towards their employer in putting their house up as collateral security for the overdraft of the company in Credit Lyonnais Netherlands NVV Birch, 1997, which would cause a bank manager to raise his eyebrows more than a little, gives some insight into the meaning of something calling for an explanation. This approach of the House of Lords is understood to have discarded the idea of manifest disadvantage, and relied more heavily upon the judgment of Allcard v. Skinner, 1887, where the court proposed the idea that where a gift is so large as not to be reasonably accounted for on the grounds of friendship, relationship, charity or other ordinary motives on which ordinary men act, then it is down to the person receiving that gift to provide an explanation. The intervention of a third party gives rise to difficulties. In practice, most litigation occurs where the relationship of undue influence arises between A and B, whereby B enters into a contract with C for the benefit of A. The most common instance of this scenario is when the relationship of undue influence exists between spouses and one spouse induces the other to enter into a transaction with a bank. The most common way in which the bank can rebut the possibility of undue influence is by notice, meaning to inform the spouse as to the nature of the transaction and advise them to seek legal advice. In Barclays Bank v. O'Brien, 1993, a wife had entered into an agreement for a charge to be placed on the matrimonial home to guarantee the overdraft of the husband's company. The transaction took place at a different branch to the one that the couple usually used, and therefore the O'Brien's bank manager had left instructions for both parties to be fully appraised of the current state of the overdraft and to advise them to speak to their solicitor if they had any concerns prior to entering into the agreement. Unfortunately, the branch did not follow their instructions, and therefore the wife was unaware of the extent of the overdraft. She thought it was at £60,000 when, in reality, it was at £135,000. When the company's overdraft reached £154,000, the bank attempted to repossess the house under the legal charge that had been placed upon it. The wife claimed that she had entered into the agreement because of the undue influence of her husband and attempted to get the transaction set aside. The court discussed policy considerations, with the growing number of cases involving wives, but rejected the idea of some form of special protection for wives or others in similar relationships, mainly because this might give a shortcut back to an automatic presumption of undue influence for such parties. The court found that the transaction was of such a nature that in order to avoid being fixed with constructive notice, the bank would have to demonstrate that certain steps had been taken by them. Constructive, or legal, notice is a presumption that a party has notice when it can discover certain facts by due diligence or inquiry into the public records. A party found to have constructive notice cannot deny knowledge of a fact because that party did not have actual knowledge, since there is a duty to conduct due investigation. Guiding the bank to appropriately handling agreements where there is potentially dangerous power or knowledge mismatch between the parties relies upon the bank being put on inquiry in certain circumstances. Those circumstances were a. The transaction is on its face not to the financial advantage of the wife, and b. There is a substantial risk in transactions of that kind that, in procuring the wife to act as surety, the husband has committed a legal or equitable wrong that entitles the wife to set aside the transaction. If it was subsequently shown that there had been undue influence, the bank would have constructive knowledge of the undue influence unless they could show that they had taken reasonable steps to establish that the wife had entered into the transaction freely and knowing the facts. The court held that, as this had not happened in O'Brien for instance, the bank had constructive notice of the undue influence and could not repossess the family home. Lord Nicholls' judgment in the Ettridge, No. 2, case provides guidance on the matter of avoiding constructive notice. The bank needs to make sure that a solicitor is named by the wife, and that this solicitor is instructed to advise separately to the husband. This can be the same solicitor that her husband uses, but the wife must be given the opportunity to nominate a separate solicitor. The solicitor must advise the wife on the nature of documents and practical implications of signing them. They must also explain that the wife will be legally bound by documents once signed. As the bank are in the best position to explain the financial situation, they must either do so, or pass on all the relevant financial data to allow the solicitor to properly explain the situation. The solicitor's role is then to advise and confirm in writing that this has taken place. Without the written confirmation from the solicitor, the bank should not proceed with the transaction. Even if it later transpires that the wife was subjected to undue influence, if these steps are followed, then the wife will not be able to use the undue influence to argue that the transaction with the bank is unenforceable. As with duress, the main remedy for undue influence is to make the contract voidable at the victim's discretion. Therefore, the ability to rescind the contract is available. As discussed earlier for duress, if no rescission has been applied for, this can be deemed to be constructive affirmation of the contract, and remedies will no longer be available. See North Ocean Shipping v. Hyundai Construction, the Atlantic Baron, 1979, case. In Allcard v. Skinner, 1887, the plaintiff had joined a religious group called Sisters for the Poor, while under the influence of her spiritual advisor. During her time as part of this group, she had given approximately £7,000 to the religious leader. She left the group and, 6 years after having left, she attempted to reclaim money that she had paid. The court found that the long delay between leaving the order and claiming the money could be construed as being a constructive affirmation of the contract, and she was not entitled to recover the money. It is useful to remember that undue influence cases are not only about disputes arising out of intimate relationships. They can be very much commercial in nature, as evidenced in the Libyan Investment Authority v. Goldman Sachs International, 2016, where Rose J. dismissed a claim by the Libyan Investment Authority in which it asserted that Goldman Sachs International had exerted undue influence over its employees, which resulted in it making improper investments and which in turn caused losses of $1.2 billion United States dollars. Goldman denied these claims and contended that, 1. The relationship did not go beyond an ordinary relationship of banks selling investment products to a wealthy client, and 2. The LIA, being a sovereign wealth fund, was a more sophisticated investor than it claimed to be. Duress and undue influence can have a significant effect upon a contractual agreement because they render a contract voidable at the discretion of the victim if proved. Duress is available at common law, whereas undue influence is an equitable doctrine, to be applied at the discretion of the court where appropriate. These two areas are considered an important part of the law of contract because that contractual agreements are supposed to be made through the free will of the parties. Duress and undue influence are considered vitiating factors, because arguably they interfere with the ability of a person to freely and willingly enter into a contract. When considering the effect of a finding of duress or undue influence, it is important to consider the impact upon parties to the contract, as well as third parties involved. The law has attempted to engage in a balancing act between the rights of a party whose will has been vitiated, and a third party who may also be innocent in the situation, yet is burdened with a duty to discharge, as is the case with banks. This is a dynamic area of the law with new cases frequently coming before the courts. We move on to a different set of problems that parties can face with contractual performance. The doctrine of frustration provides that if, after a contract is entered into, events occur without the fault of either party which make it impossible physically or commercially, if it loses its commercial purpose, to perform the contract, then it is automatically terminated, so as to relieve both parties of their future obligations under it. Whether or not a contract will be regarded as frustrated depends upon the obligations created by the contract and the circumstances that occur. It is key to remember that frustration is exceptional and provides one of a variety of ways by which contractual obligations end. Where a contract is discharged by frustration, this occurs automatically by operation of law. The courts decide when a contract has been frustrated and, if they decide that it has, then all future obligations cease. The consequences of this are dealt with by both common law rules and statute. The Law Reform, Frustrated Contracts, Act 1943. Key cases explaining the requirements for frustration include Taylor v. Caldwell, 1863, and Davis Contractors Limited v. Fareham Urban District Council, 1956. We will start our overview of this area of the law by looking at some of these key cases. In Taylor v. Caldwell, 1863, the courts regarded most contractual obligations as absolute. As the promisor promised to perform, come what may, he could not rely upon supervening events, other than breach of contract by the other party, as an excuse for non-performance. In Lauritsen v. Weimar BV, known as the superservient 2, remember that shipping cases are normally referred to using the name of the vessel. Bingham L.J. explained that certain propositions, established by the highest authority, are not open to question. 1. The doctrine of frustration was evolved to mitigate the rigor of the common law's insistence on literal performance of absolute promises. The object of the doctrine was to give effect to the demands of justice, to achieve a just and reasonable result, to do what is reasonable and fair, as an expedient to escape from injustice where such would result from enforcement of a contract in its literal terms after a significant change in circumstances. 2. Since the effect of frustration is to kill the contract and discharge the parties from further liability under it, the doctrine is not to be lightly invoked, must be kept within very narrow limits and ought not to be extended. 3. Frustration brings the contract to an end forthwith, without more and automatically. 4. The essence of frustration is that it should not be due to the act or election of the party seeking to rely on it. 5. A frustrating event must take place without blame or fault on the side of the party seeking to rely on it. An example of this harshness of the rules of contract before the evolution of the doctrine of frustration, that Bingham L.J. mentioned is Paradine v. Jane, 1647. In that case, a farm tenant was excluded from his farm for 2 years by enemies of the king, and claimed that he was not liable for the rent for the period he was dispossessed. It was held that he was liable regardless, as he had assumed the obligation. In situations where there is a change in circumstances, not attributable to the fault of either party, such that performance of the contract would become something radically different from what the parties originally intended, justice requires that the courts should treat the contract as having come to an end. See National Carriers Limited versus Panalpina, Northern, Limited, 1981. It is quite possible for the parties themselves to make provision in the contract for what is to happen should the performance of the agreement become impossible, or radically different, as a result of some subsequent event for which neither of them is to blame. This is common in commercial contracts, which frequently use what are known as force majeure clauses. Where there is a clause of this type which covers the situation which has occurred, then the courts will give effect to it. The issue will not longer be one of frustration, as contractual provision will take precedence. We only talk of frustration when the event is not in fact addressed by the agreement between the parties. Be careful with this distinction, as in most jurisdictions material on force majeure and frustration will be distinct. We now move to discuss more closely the nature of possible frustrating events. Courts have consistently indicated that a contract will be frustrated only where there is a complete change between what was undertaken in the contract and the circumstances in which it is called upon to be performed. See for example CTI Group Inc. vs. Transclear SA, 2008. The following types of frustrating events have been noted in the case law: destruction of the subject matter, personal incapacity, non-occurrence of an event, or failure of the commercial purpose, effects of war and other government action. We now look at each of them in turn. Destruction of subject matter. The most obvious example is where the main subject matter of the contract has been destroyed, as in Taylor v. Caldwell, 1863. In this case, defendants Caldwell and Bishop owned Surrey Gardens and Music Hall, and agreed to rent it out to the plaintiffs, Taylor and Lewis, at the rate of £100 per day. The plaintiffs had planned to use the music hall for 4 concerts for 4 different dates during the summer of 1861, and had intended to provide a variety of extravagant entertainments. According to the contract the parties had signed, the defendants were to provide most of the performers. The plaintiffs were to receive the gate receipts and advertise for these events. Then, tragically, on June 11, 1861, a week before the concert was to be given, the music hall burned to the ground. The plaintiffs sued the music hall owners for breach of contract for failing to rent the music hall. There was no clause within the contract itself which allocated the risk to the underlying facilities, except for the phrase, "God's will permitting," at the end of the contract. Judge Blackburn reasoned that the rule of absolute liability set forth in Paradine v. Jane only applied to positive, definite contracts, not to those in which there was an express or implied condition underlying the contract. Blackburn further reasoned that the continued existence of the music hall in Surrey Gardens was an implied condition essential for the fulfillment of the contract. The destruction of the music hall was the fault of neither party, and rendered the performance of the contract by either party impossible. Blackburn cited to the Civil Code of France and the Roman law for the proposition that when the existence of a particular thing is essential to a contract, and the thing is destroyed by no fault of the party selling it, the party are freed from obligation to deliver the thing. He further analogized to a situation in which a contract requiring personal performance is made, and the party to perform dies. The party's executors are not held liable under the common law of England. Blackburn thus held that both parties were excused from their obligations under their contract. Personal incapacity. Another clear case of frustration will be where both parties have agreed that the contract is to be carried out by a particular individual, and that individual dies, or is too ill to perform. See Condor v. Baron Knights, 1966. In Hart v. Marshall & Sons, 1978, employee began employment as a night service fitter in 1968. In April 1974 he became ill, and during his absence from work he sent regular medical certificates to his employers. On January 27, 1976, when he told the employers that he had recovered, they informed him that there was no longer any work for him and gave him his P45 form and holiday pay. On the employee's complaint of unfair dismissal, there was no evidence before the Industrial Tribunal of the terms of the contract of employment, and the tribunal heard the complaint on the basis that there were no contractual terms regulating the position of a sick employee and that he was not entitled to be paid during his absence. The tribunal found that the employee was a key worker and that the employers were justified in engaging a replacement fitter after the employee had been absent for 4 months, that the employers had not dismissed the employee but that his contract had been terminated by frustration, and they dismissed the complaint. On the employee's appeal, the court held that the Industrial Tribunal were correct in holding that the contract was frustrated and the employee had not been dismissed. Non-occurrence of an event. A number of cases concerned with the cancelled coronation of King Edward VII in 1903 illustrate this category. See Krell v. Henry, 1903, and Herne Bay Steamboat County v. Hutton, 1904. The core of these cases is the idea that if the commercial purpose of the contract has failed completely, then the contract should be considered frustrated. In Krell v. Henry, 1903, the defendant agreed to hire from the plaintiff a flat in Pall Mall for June 26 and 27, on which days it had been announced that the coronation processions would take place and pass along Pall Mall. The coronation of Edward VII and Alexandra of Denmark as King and Queen took place at Westminster Abbey, London, on the 9th of August 1902. Originally scheduled for the 26th of June of that year, the ceremony had been postponed at very short notice, because the king had been taken ill and required immediate surgery. The contract contained no express reference to the coronation processions, or to any other purpose for which the flat was taken. A deposit was paid when the contract was entered into. As the processions did not take place on the days originally fixed, the defendant declined to pay the balance of the agreed rent. The court held from necessary inferences drawn from surrounding circumstances, recognized by both contracting parties, that the taking place of the processions on the days originally fixed along the proclaimed route was regarded by both contracting parties as the foundation of the contract, that the words imposing on the defendant the obligation to accept and pay for the use of the flat for the days named, though general and unconditional, were not used with reference to the possibility of the particular contingency which afterwards happened, and consequently that the plaintiff was not entitled to recover the balance of the rent fixed by the contract. In other words, therefore, the postponement of the coronation meant that the contract had been frustrated and the parties were released from the obligation of further performance. Not all cases arising from these facts, however, led to the same conclusion. Herne Bay Steamboat County v. Hutton, 1903, arose from the same set of events. In consequence of the public announcement of an intended Royal Naval Review at Spithead on June 28, 1902, an agreement in writing was entered into between the plaintiffs and the defendant that the plaintiff's steamship Cynthia should be at the disposal of the defendant on June 28 to take passengers from Herne Bay, for the purpose of viewing the Naval Review and for a day's cruise round the fleet. Also on June 29 for similar purposes. Price payable before ship leaves Herne Bay. On the signing of the agreement, the defendant paid a deposit. On June 25 the review was officially cancelled, whereupon the plaintiffs wired to the defendant for instructions, stating that the ship was ready to start, and also requesting payment of the balance. Receiving no reply, the plaintiffs, on June 28 and 29, used the ship for their own purposes, thereby making a profit. On June 29 the defendant repudiated the contract. During the 2 days in question the fleet remained anchored at Spithead. In an action by the plaintiffs to recover the balance less the profits made by their use of the ship during the 2 days, it was held that the plaintiffs were entitled to recover, because the venture was the defendant's, the risk being his alone, and the happening of the Naval Review was not the sole basis of the contract, so that there had been no total failure of consideration, nor a total destruction of the subject matter of the contract effects of war. In time of war, a government may make trading with companies based in enemy territory illegal. Contracts with such companies which were made prior to this action will be frustrated. The key case here is Fibrosa Spolker Aktiena versus Fairbairn Lawson Coombe Barber Limited, 1943. Note, however, that frustration need not result from direct government action, as in Finelvatag versus Vinava Shipping County Limited, 1983. In Fibrosa Spolker Aktiena Appellants versus Fairbairn Lawson Coombe Barber, 1943, an English company agreed to sell and the appellants, a Polish company, agreed to purchase machinery of which 1/3 was to be paid with the order. Delivery was to be 3 to 4 months from settlement of final details, and the goods were to be packed and delivered to Poland. The sale was made subject to certain conditions, including a provision that stated, should dispatch be hindered or delayed by any cause whatsoever beyond our reasonable control, including war, a reasonable extension of time shall be granted. On September 1, 1939, war broke out between Germany and Poland, and on September 3 Great Britain declared war on Germany. On and after September 23, the delivery port was occupied by the Germans. It was held that, contractual provision being limited in its ambit to a delay in respect of which a reasonable extension of time might be granted, did not prevent frustration of the contract by reason of the war on the ground that it made express provision for that contingency, since this war involved prolonged and indefinite interruption of prompt contractual performance, and that, there having been a total failure of consideration, the appellants could recover partial payments made by the respondents. Other government action. Government action not related to war can also frustrate a contract. See Gameco SA vs ICM, Fair Warning Agency, 1995. Gameco were promoters who entered into an agreement to promote a concert in Madrid with the defendants, the corporate persona of the band, Guns N' Roses. A few days before the concert, engineers reported the venue was structurally unsound and the authorities banned its further use pending further investigations. Gameco's license to use the venue was revoked. Gameco had paid the defendants large sums on account and they sought recovery. It was held that the contract was frustrated because it had become incapable of performance because the authority cancelled the permit. A term was implied into the contract that Gameco would take all reasonable steps to attain the permit, but they were not required to ensure it remained in force. They could, therefore, recover the advance payments under S.1.2 of the 1943 Act. Other frustrating events. Other types of event which have led to contracts being frustrated include industrial action, as in the NEMA, 1981, and the accidental running aground of a ship. See Jackson v. Union Marine Insurance County Limited, 1874. Inordinate delay could form a basis for frustration as well, as in Bankline v. Capel, 1919. There are two principal limitations on the doctrine of frustration. The first is where the frustrating event has been foreseen and provided for in the contract. The second is where the alleged frustrating event has been self-induced by one of the parties. In the commercial area, force majeure and similar clauses may well replace the common law and statutory rules on frustration. The courts have tended to narrowly interpret such clauses. See Jackson v. Union Marine Insurance County Limited, 1874. First, we deal with the issue of foreseeability. The case of Ocean Tramp Tankers Corp. vs. V.O. Sovfract, the Eugenia, 1964, illustrates these key limitations well. First of all, we can consider how foreseeable does the event need to be to prevent frustration. A. If there is contractual provision for this event, no frustration. B. If the event not covered, how different is it from the situations provided? Lord Denning argued that a contract would be frustrated if it were unjust to hold the parties to the bargain. We can inquire therefore if the contract has become something radically different. The Eugenia was let to the charterers for a trip out to India via Black Sea, from the time the vessel was delivered to the charterers at Genoa. The charter party contained a customary war clause, which provided the vessel, unless the consent of the owners be first obtained, not to be ordered nor continue to any place or on any voyage nor be used on any service which will bring her within a zone which is dangerous as the result of any actual or threatened act of war, war hostilities, warlike operations. Quote. When the charter party was negotiated, the agents of both parties realized that the Suez Canal might be closed, but no express terms were inserted in the charter to meet that eventuality. The vessel was delivered at Genoa. She sailed from Odessa, the customary route at this time to India being still by the Suez Canal. She arrived at Port Said when Egyptian anti-aircraft guns were in action. Port Said and the Suez Canal were then zones which were dangerous within the clause. The vessel entered the canal and proceeded south. The canal was blocked by the Egyptian government, and the vessel was trapped. The charterers claimed that the charter party had been frustrated by the blocking of the canal. The owners denied frustration. They treated the charterers' conduct as repudiation and claimed damages. The court held that this was a time charter, the essence of which was that the ship owners placed the vessel at the disposal of the charterers. The vessel was under the charterers' orders when she approached the Suez Canal, and the charterers were in breach of the war clause when they ordered her to enter the canal. The blocking of the Suez Canal did not bring about so fundamentally different a situation as to frustrate the venture. It becomes therefore necessary to determine whether a party assumed the risk of the occurrence of the event that lies at the root of the inability to perform the contract. Further, if performance is rendered merely more expensive, inconvenient, difficult, the contract will not be frustrated as a result. In Davis Contractors v. Fareham Urban the 600th, 1956, Lord Reed said that, "It appears to me that frustration depends, at least in most cases, not on adding any implied term but on the true construction of the terms which are in the contract, read in the light of the nature of the contract and of the relevant surrounding circumstances when the contract was made." On this view, there is no need to consider what the parties thought, or how they or reasonable men in their shoes would have dealt with the new situation if they had foreseen it. The question is whether the contract which they did make is, on its true construction, wide enough to apply to the new situation. If it is not, then it is at an end. According to Lord Radcliffe, frustration occurs whenever the law recognizes that, without default of either party, a contractual obligation has become incapable of being performed because the circumstances in which performance is called for would render it a thing radically different from that which was undertaken by the contract. It was not this that I promised to do. The case involved plaintiffs agreeing to build 78 houses for the defendants. The work was to be completed within 8 months. Before the contract was signed, the plaintiffs had written to the defendants, "Our tender is subject to adequate supplies of material and labor being available as and when required to carry out the work within the time specified. Owing to bad weather, but more particularly to an unforeseen shortage of available labor, due to an unexpected lag in the demobilization of troops after the war, the work took 22 months to complete." The contractors received the contract price, but they claimed that by reason of the delay they were entitled to treat the contract as void and to be paid on a quantum meruit, meaning payment for work done outside a contract. The House of Lords held that in a contract of this kind the contractor undertook to do the work for a definite sum, and he took the risk of the cost being greater or less than he expected. If delay occurred through no one's fault, that might be in the contemplation of the contract and there might be provision for extra time being given. To that extent the other party took the risk of delay. But he did not take the risk of the cost being increased by such delay. It might be that delay could be of a character so different from anything contemplated that the contract would be at an end, but in this case the most that could be said was that the delay was greater in degree than was to be expected. It was not caused by any new and unforeseeable factor or event. The job proved to be more onerous, but it never became a job of a different kind from that contemplated in the contract. We now move on the issue of self-inducement of the frustrating event. Another important element in the doctrine of frustration is that the alleged frustrating event must not be attributable to the fault of either party. If it is, then the likelihood is that the party at fault will be in breach of contract and the doctrine of frustration will have no application. The courts have interpreted the concept of fault widely in this context. In fact, it may be more accurate to say that wherever the alleged frustrating event is attributable to the actions of one of the parties, whether these involved fault or not, then the doctrine of frustration will not apply. See Maritime National Fish v. Ocean Trawlers, 1935. In Lauritsen as versus Weimüller BV, 1990, the defendants, Weimüller, agreed to carry the plaintiff's, Lauritsen's, drilling rig, Dan King, from the Hitachi shipyard at Ayake, Japan to a delivery location off Rotterdam. The drilling rig was to be delivered between June 20, 1981 and August 20, 1981 and was to be carried by using what the contract described as the transportation unit. The unit was defined as meaning Superservant 1 or Superservant 2. The defendants were given the right to cancel the performance under the contract in the event of force majeure or any other circumstances whatsoever which reasonably prevented the performance of the contract. The defendants also had the right to substitute the transportation unit by other means of transport, and there was a duty of care clause in which the defendants agreed to do everything that a good carrier might reasonably be expected to do in order to reach the port of discharge in time and safety. On January 29, 1981, Superservant 2 sank. The defendants had intended to use Superservant 2 for this contract. They had entered into other contracts with other persons which they could only perform using Superservant 1. On or about February 16, 1981, the defendants informed the plaintiffs that they would not carry out the transportation of the drilling rig with either Superservant 1 or Superservant 2. The plaintiffs claimed the losses they had suffered and the defendants counterclaimed in respect of the increased expenses they had incurred. The court held that under the contract the defendants could have satisfied their obligation by using Superservant 1 to carry Dan King after Superservant 2 had sunk, but they elected not to do so. The doctrine of frustration only availed a party who contracted to perform a contract of carriage with a vessel which through no fault of his own no longer existed, but that was not this case. The Dan King contract did provide an alternative. The sinking of Superservant 2 did not automatically and without more ado bring the contract to an end by reason of frustration. Even after the sinking, the defendants could have used Superservant 1. The real question was whether the frustrating event relied on was truly an outside event or extraneous change of situation, or whether it was an event which the party seeking to rely on it had the means and opportunity to prevent but nevertheless caused or permitted to come about. One common law rule which operates even where the act is also applicable is that a frustrating event terminates the contract automatically, without any need for action by either party. It follows that any attempt to affirm the contract following frustration will be ineffective. See here G. Mulji v. Chongyong Steamship County Limited, 1926. As to the distribution of losses following frustration, the common law started from the position that all future obligations were discharged, post the frustrating event, but that obligations incurred prior to the event survived. Where the loss fell would therefore depend entirely on what the contract said about when payment was to be made, or when work was to be done. See Chandler v. Webster, 1904, and Fibrosa Spolker Aktiena v. Fairbairn Lawson Coombe Barber Limited, 1943. The inflexibility of the common law rules, even following the slight modification provided by the Fibrosa case, led to demand for reform. This occurred in the shape of the Law Reform, Frustrated Contracts, Act 1943. The two main provisions in the 1943 Act are S.1.2, which deals with money paid or payable prior to the frustrating event, and S.1.3, which deals with benefits conferred prior to that event. Section 1.2 provides that where money was paid or payable prior to the frustrating event, it should be returned, if paid, or should cease to be payable, if not paid but owing. Unlike the common law, this is not dependent on there being a total failure of consideration. A total failure of consideration will entitle a claimant to seek a restitutionary remedy. Wincup v. Hughes, 1871, is authority for the proposition that the claimant may seek a restitutionary remedy by saying that the basis upon which he conferred a benefit has failed entirely, in this case because of the defendant's breach of contract. If any part of the contract is performed, or if the claimant has received any part of the consideration, the restitutionary claim is barred. See Tinsley v. Milligan, 1993, and Lipkin-Gorman v. Carpnell, 1992. Section 1.2 of the 1943 Act provides that if expenses have been incurred towards the performance of the contract, some of the money paid or payable may be retained or recovered, to the extent that a court considers it just in all the circumstances. Section 1(3) deals with the situation where a party has received a benefit other than money prior to the point at which the contract was frustrated. In that situation, the section allows that the party to recover from the other party such sum as the court considers just, having regard to all the circumstances of the case. In BP Exploration Co., Libya, Limited v. Hunt, No. 2, 1979, BP entered an agreement with Hunt, under which BP would explore and develop his oil concession in Libya at their own expense. This expenditure would be recoverable from Hunt's share of the profits when the field produced oil. After oil production began, the parties would share both production and development costs. Oil came on stream in 1967, but in 1971 the Libyan government seized BP's interest. BP had not received all its initial expenditure from Hunt's share, and arguing that the contract had been frustrated by government action, claimed a just sum under S1 Law Reform, Frustrated Contracts, Act 1943. The court held that the contract had been frustrated in 1971. At the date of frustration, Hunt had received a benefit under the contract because of BP's contractual performance, and this sum was to be taken into account. This completes our presentation of the main features and operations of the English law doctrine of frustration. We now move on to a summary of the main aspects of the doctrine of misrepresentation. We will see what an actionable misrepresentation is and will discuss potential remedies such as rescission of the contract and damages. Finally, we will present how any attempts to exempt liability for a misrepresentation can operate under the Unfair Contract Terms Act 1977 and the relevant provisions in the Consumer Rights Act of 2015. When negotiating a contract, the prospective parties may say many things which are designed to encourage the other party to enter into the contract. Sometimes these statements become terms of the eventual contract. If they do not, a remedy may nevertheless be available to a party who has been induced to enter into a contract in reliance on a falsehood. After the Misrepresentation Act 1967, more extensive remedies in damages available for misrepresentation were introduced into English law, under S.2 of the Act, and S.1a provides that a contract may be rescinded for misrepresentation, even if the misrepresentation is also a term of the contract. For a misrepresentation to be actionable, it must be a false statement of existing fact or law. A statement of opinion is not generally a misrepresentation. See Bissett v. Wilkinson, 1927. Two exceptions exist. The first is where the person expressing the opinion is aware of facts which indicate that the opinion cannot be sustained. See Smith v. Land House Corporation, 1884. The second exception, which can lead to a statement of opinion being treated as a false statement of fact, is where there is evidence that the person making the statement does not believe it at the time that it is made. Proof that the maker of the statement was aware of contradictory facts may prove that they did not believe the statement was true. See Edgington v. Fitzmaurice, 1885. Traditionally, statements of law were not regarded as being statements which, if false, will give rise to remedies for misrepresentation. It seems, however, that now that the House of Lords has recognized the possibility of restitutionary remedies for mistake of law, in Kleinwort Benson Limited v. Lincoln City Council, 1999, the same approach may well apply in the area of misrepresentation. If the statement of law is not believed by the person making it, then the principle in Edgington v. Fitzmaurice will apply, so that the statement will be treated as a misrepresentation of the person's state of mind. Let us explore the above possible misrepresentations through a list of examples. If Yorgos buys John's bicycle after being told that it is a mountain bike and it turns out to be a street bike, would he have a claim for misrepresentation? The answer would be yes, as a false statement of fact was made that induced John to enter into the contract. If on the other hand Yorgos told John that he thinks this is a great bike, this is unlikely to be sufficient basis for a finding of misrepresentation, as it sounds like a statement of opinion, and it is not specific enough to be manifestation of expertise or an outright lie. If Yorgos knew that the bike is faulty, but did not share that information, then there is no statement on which to base a misrepresentation action. Similarly, if Yorgos promised to include a lock chain with the bike, but then fails to provide it, then we should be talking about a breach of contract, promise of future action, rather than a false statement. We will now move on to see the requirements for actionable misrepresentation in some more detail. In order for a misrepresentation to be actionable, it must induce the person to whom it is addressed to make a contract. This simply means that the statement must be one of the factors which led the person to enter into the contract. It does not have to be the sole or main reason. See Edgington v. Fitzmaurice, 1885. The representation must play a real and substantial part of the claimant's decision to enter into the contract. See Redgrave v. Hurd, 1881. If the misrepresentation would have induced a reasonable person to contract, the court will presume that it did so induce the representee to contract in this instance. Is it possible to induce misrepresentation by silence? A misrepresentation generally requires an oral or written statement. There are, however, some exceptions to this. First, it is clear that in certain situations conduct can be treated as implicitly making a statement. If the implicit statement turns out to be untrue, then it may be a misrepresentation. See Spice Girls Limited v. Aprilia World Service BV, 2000. The case involved the iconic 90s girl group. The group signed a sponsorship agreement, but subsequently resisted payment, saying that one of the five, Jerry, also known as Ginger Spice, had given notice to leave the group, substantially changing what had been promised. The girls acknowledged that Jerry had said she would leave, but insisted that no real intention to leave had existed. The court accepted that a person who is about to enter into an agreement is under no duty to disclose material facts which she knows but which the other party does not know. Here, however, the group knew that the other party was relying upon a representation that was false and were as consequence liable in damages. Secondly, where a statement, which was true when made, becomes false as a result of a change of circumstances, keeping silent may be treated as a misrepresentation. See with V. O'Flanagan, 1936. Additionally, there are some contracts which are treated as being of the utmost good faith. This means that parties are obliged to disclose relevant information, even if it is not asked for. See Lambert v. Cooperative Insurance Society, 1975. There are 4 different categories of misrepresentation, which relate principally to the state of mind of the person making the statement. Fraudulent. The maker of the statement knows or believes that the statement is untrue, or makes it not caring whether it is true or false. Negligent at common law. The maker of the statement and the person relying on it are in a special relationship, giving rise to a duty of care under the principles of Hedley-Byrne v. Heller, 1964, and the maker of the statement acts in breach of this duty. Statutory misrepresentation. The maker of the statement has no reasonable grounds for believing it to be true. S.2, 1. Misrepresentation Act 1967. See also Foster v. Action Aviation Limited, 2013. Innocent. The maker of the statement genuinely believes it is true, and does not act negligently, at common law or under statute, as above, in making it. The distinction between these categories is vital in determining the remedies which may be available to the person relying on the statement. We now move to consider what remedies are available for misrepresentation depending to its type and circumstances. The remedies available for misrepresentation will depend on whether it was made innocently, negligently, or fraudulently. There are potential remedies available under the common law, both in contract and tort, and under statute. The Misrepresentation Act 1967. The main categories of remedy are first, rescission of the contract, and secondly, damages for losses resulting from the misrepresentation. Rescission is the principal common law remedy for a misrepresentation which induced a contract. This was, and is still, available whether the representation was innocent, negligent, or fraudulent. Rescission, in this context, means that the contract is set aside, and the parties put into the position they would have been in had the contract never been made. Any goods or money which have been exchanged must be returned. The remedy of rescission must be sought by the claimant. It does not occur automatically. It is important to remember that misrepresentation renders a contract voidable, rather than void. There are some situations where the right to rescind will be lost. These are, where a party to the contract, aware of the other party's misrepresentation, continues with the contract, and thus, affirms it. See Long v. Lloyd, 1958. Where there is a significant lapse of time between the making of the contract and the discovery of the misrepresentation. See Leaf v. International Galleries, 1950. Where restitution is impossible. Since the idea of rescission is to restore the parties to the position they would have been in had the contract not been made, if property which has been transferred has been consumed or inextricably mixed with other property, rescission will not be permitted. See Clark v. Dixon, 1858. where rescission would affect the rights of a third party. The most obvious example is where goods have been sold to the misrepresenter, who has then sold them on to an innocent third party before the contract has been avoided. The common law was late in recognizing a right to damages for non-fraudulent misrepresentations. An innocent misrepresentation provided only an indemnity for necessary expenditures incurred as a part of the contract rescinded by way of monetary compensation. See Whittington v. Seal-Hayne, 1900. Where a misrepresentation is fraudulent, damages may be recoverable under the tortious action for deceit. This requires the claimant to prove that the statement was made knowing that it was untrue, without any genuine belief in its truth, or with a reckless disregard for whether it was true or not. See Derry v. Peake, 1889. The law of tort, in Hedley Byrne v. Heller, 1964, eventually recognized that a negligent misstatement which caused economic loss could be actionable. The action that has developed from this provides another potential remedy for a person who has entered into a contract as a result of a negligent misstatement from the other party. The most important innovation in the Misrepresentation Act 1967 was the introduction of the action for what is generally referred to as negligent misrepresentation, in S.2.1. In fact, the Act does not use this terminology, but provides that a statement which would form the basis of an action in deceit, if made fraudulently, will also give rise to liability unless the person making it is able to prove that he had reasonable grounds to believe and did believe up to the time that the contract was made that the facts represented were true. On the burden of proof, all that the claimant has to do is to prove that a misrepresentation was made and that it induced the contract. The defendant will then be liable for damages under S.2.1, unless he or she can prove that there were reasonable grounds for his or her belief that the statement was true. See Howard Marine and Dredging County v. Ogden and Sons, 1978. As regards the measure of damages, the most important authority is Royscott Trust Limited v. Rogerson, 1991. Here it was held by the Court of Appeal that damages under S.2.1 should be calculated in the same way as if the statement had been made fraudulently. Section 2(2) of the Misrepresentation Act provides a discretion for a court to award damages in lieu of rescission, where it is judged equitable to do so, taking account of the effect of rescission on both parties. The exclusion or limitation of liability for misrepresentation is dealt with by S.3 of the Misrepresentation Act 1967, as amended by S.8 of the Unfair Contract Terms Act 1977. This requires that any clause which attempts to limit liability for misrepresentation must satisfy the requirement of reasonableness set out in S.11 of the Unfair Contract Terms Act, Chapter 6. See Avrora Fine Arts Investment Limited v. Christie, Manson & Woods Limited, 2012. Broad attempts to exclude liability have been found to be unreasonable, even if the clauses are drawn from widely used standard conditions. Sometimes the attempt to exclude liability is put into the form of an assertion, for example, that no statements are made other than those contained in the contract itself. Such entire agreement clauses have been considered in a number of cases. Although there is an early authority, on the pre-UCTA version of S.3, which held that such a clause could be effective to restrict liability for statements made by an agent of the party concerned, Overbrick Estates v. Glencombe Properties, 1974, subsequent cases have generally taken the line that an entire agreement clause, or clauses, which attempt to deny that there is any reliance on pre-contractual statements, do fall within the scope of S.3 as far as liability for misrepresentation is concerned. They would therefore not be successful in protecting a party from a misrepresentation claim. Under the Consumer Rights Act 2015, a new concept of a consumer notice has been introduced. See Part 2 of the Act on Unfair Terms. This means that anything which sets out the rights or obligations of the trader and consumer or restricts the trader's liability will be subject to the same test of fairness as if they were set out in a trader's terms and conditions. This will apply to marketing communications, brochures, and signs at premises, all of which will be treated in the same way as if they were contract terms. Anything said or written to a consumer about a service or trader, whether by or on behalf of the trader, will be treated as a term of the contract if the consumer takes it into account when deciding whether to enter into the contract, and when making any decision about the services after the contract is entered into. This makes it a great deal easier for consumers to bring claims which would previously have had to be pursued under the law of misrepresentation. This presentation offered a summary of the main aspects of the doctrine of misrepresentation. We presented the main elements of misrepresentation, explained what an actionable misrepresentation is, which categories it comes in, and then moved on to consider remedies. We presented rescission and damages, and concluded with a reflection on options for limiting liability for misrepresentation. We conclude our list of contractual problems with the doctrine of mistake. Mistake is a difficult area of contract law. A major reason for the difficulty is that the common law recognizes no comprehensive theory of mistake. Consequently, many of the decisions are difficult to reconcile with each other. This difficulty is made worse by the fact that the number of mistake cases is quite small. A further complication is that judges, authors, and lawyers often use different terms to describe the same concept. Mistakes can be either unilateral, a mistake of one party only, or bilateral, a mistake of both parties. In general, the law will only provide relief where the mistake is a bilateral mistake, although there are some important exceptions to this point. The parties may share the same bilateral mistake, it is a common or mutual mistake, or they may each be mistaken, but with respect to a different point. At common law, an operative mistake will render a contract void. In equity, the effect of mistake is said to render the contract voidable. Equity seeks to provide whatever remedy is just in the circumstances. Mistake in equity rendering a contract voidable is, however, doubted in English law at present. Mistake at common law and in equity. The most significant division is between mistake at common law and mistake in equity. We will begin with mistake at common law, because if the mistake is an operative one, the contract is void, and there is no need to consider mistake in equity. Mistakes of law and mistakes of fact. English contract law long barred relief where the mistake was one of law rather than of fact. Absence of genuine agreement. In situations where there is an absence of genuine agreement, the parties are each mistaken, but they do not share a mistake. Their separate mistakes are sufficiently fundamental, however, that no contract can be created. It is sometimes said that the parties are at cross purposes, and that the offer and acceptance do not correspond. No contract can arise if there is an absence of agreement. See Raffles v. Wichelhaus, 1864. Common mistake. Common mistake occurs where both parties to a contract are mistaken about a critical element of their agreement. They share this mistaken assumption. See Bell v. Lever Brothers, 1931. Common mistake deals with those situations where an apparent contract lacks consent, that the apparent consent of the parties is not present and consequently the contract is void ab initio, void from the outset. Mistake operates to disrupt this consensus. It removes any consensus and consequently no contract can arise in the circumstances. Non-existence of the subject matter. In some situations, parties may reach an agreement to deal with a subject matter which, unknown to either party, does not exist. These cases deal with the problem of res extincta. Note that in these cases, the contract suffers from an initial impossibility. See Couturier v. Hasty, 1856, McRae v. Commonwealth Disposals Commission, 1951. Where the subject matter of the contract does not exist at the time of the contract, courts will find that the contract is void. This will not occur where the mistake is brought about by the negligence of one party. Mistakes as to ownership. Like the situation of the non-existent subject matter, these cases involve a situation of initial impossibility. One party agrees to sell and the other party agrees to buy something which, unknown to either of them, is already owned by the buyer. The agreement is impossible to perform because it is impossible to transfer the ownership since the buyer already owns the thing. See Cooper v. Phibbs, 1867, and Bly v. Martin, 1966. Mistake as to the possibility of performance. In some circumstances, the parties may be mistaken as to the possibility of performance. The parties have a shared misapprehension that performance of their agreement is possible. There are three main categories of cases. Cases of physical impossibility. See Sheikh Brothers Limited vs. Oxner, 1957. Cases of legal impossibility. See Cooper v. Phibbs, 1867. Cases of commercial impossibility. See Griffith v. Brymer, 1903. Mistake as to equality of the subject matter. In Bell v. Lever Brothers Limited, 1931, where Lord Atkin wrote the leading judgment, he recognized that a mistake as to quality may render the contract void. Mistake as to quality of the thing contracted for raises more difficult questions. In such a case, mistake will not affect assent unless it is the mistake of both parties, and is to the existence of some quality which makes the thing without the quality essentially different from the thing as it was believed to be. The problem the case creates is that if the mistake was not sufficient in this case, it almost never would be. It is probably for this reason that there have been so few successful mistake cases in later years. In the case of Associated Japanese Bank, International, Limited v. Credit du Nord S.A., 1988. Stein J., as he then was, explained the meaning and application of Bell v. Lever Bros. This is an important case because it provides a comprehensive assessment of contractual mistake. Stein J. stated that the doctrine of mistake at common law had a narrow ambit, and one into which few cases had fallen. To an extent which has yet to be determined, this case is affected by the decision in the Great Peace, 2002. Courts are generally unwilling to find that a contract is void at law where the mistake is the mistake of one party only. To find the contract void would, in most instances, prejudice the non-mistaken party. Accordingly, courts will generally only find the contract void in one of two situations. In the first case, the non-mistaken party is aware of the other party's mistake and proceeds to contract anyway. In the second case, the non-mistaken party has created the mistake to induce the, now, mistaken party to contract. The largest group of these cases are those of mistaken identity. Mistaken assumptions or promises. In some circumstances, mistake is said to negative the consent of the mistaken party so that no contract arises. The mistake prevents the contract from arising. Importantly, the non-mistaken party must be aware of the other party's mistake. See Smith v. Hughes, 1871. Where the mistake is as to an assumption or as to a promise, courts rarely find that the mistake is operative, that is to say, that, because of the mistake, no contract has been created. The entire area displays the extent to which the common law of contract is rooted upon the principle of caveat emptor, let the buyer beware. In some instances, however, it is so readily apparent to the one party that the other is proceeding upon a mistaken basis that the court will find that the apparent contract is void. See Hartog v. Collin and Shields, 1939, and Centrovincial Estates v. Merchant Investors, 1983, mistakes as to identity. This area of law has received recent clarification from the House of Lords in the case of Shogun Finance v. Hudson, 2003. The court is faced with litigation between the deceived and mistaken vendor as claimant and the innocent third party as defendant, in which the claimant seeks the return of his goods. The court must decide which of these two parties will bear the cost of the rogue's deception. In the above circumstances, the rogue induced the contract by a misrepresentation. If the contract is not void for mistake, it is voidable for misrepresentation. However, the vendor must then set aside or rescind the contract before the innocent third party contracts with the rogue. In most mistaken identity cases, the policy arguments will favor protection of the third party. In Shogun Finance v. Hudson, a rogue entered into a written contract of hire purchase with Shogun Finance to purchase a vehicle on credit. The rogue fraudulently assumed the identity of another person. The majority of the law lords found that in these circumstances, identity was critical to Shogun Finance because it was necessary for them to check the credit rating of their potential borrowers. The apparent contract was a nullity due to the mistake of identity and an absence of consensus. The majority also approved of a presumption that in the face-to-face cases the party deceived intended to deal with the person physically before him, and the result is the formation of a voidable contract. Rectification. Equitable relief takes three principal forms. The first is rectification, and this is a remedy which is concerned with correcting a mistake which occurs not in the making of the agreement, but in the recording of the agreement. There is little difficulty in ascertaining the principles of this form of relief. The possibility of rectification exists where a written contract or deed fails to express the common intention of the parties. Even a unilateral mistake may be a sufficient basis for rectification where it is known to the other party and that party fails to draw the mistaken party's attention to it. What is important in relation to rectification is that it exists where the mistake is made in the recording of the agreement only. Because rectification is an equitable device, the usual restrictions as to its application apply. Such restrictions encompass matters such as a lapse of time. A claim for rectification will be barred when a period of time has elapsed, or the intervention of third-party rights. A claim for rectification cannot be made against a bona fide purchaser for value without notice of the mistake, or the conduct of the party who seeks rectification. It is an equitable maxim that he who comes to equity must come with clean hands. Specific performance. It is in relation to the second and third forms of equitable relief that uncertainty exists as to the extent to which there is a doctrine of equitable relief. The second form of equitable relief flows from the nature of the remedy itself. The principal characteristic of specific performance is that it is discretionary, that is, flexible and responsive to the justice of the individual case. Rescission. Equity, historically, could intervene to rescind the contract. Rescission in this context meant that the contract is voidable by the court and not by one of the parties. A court of equity could also rescind the contract upon those terms which the court considered just in the circumstances. It is important to note at the outset that equitable relief will not be available where the party has made a unilateral mistake as to the commercial consequences of the contract he had entered into rather than the terms of the agreement or the subject matter of the agreement. The difficulty stems from working out whether or not equity has any ability to intervene in cases where there is a common mistake, but not one which is of sufficient importance to render the contract void at law. It was in this context that the Court of Appeal gave the decision in the Great Peace, 2002. The Court of Appeal extensively reviewed the cases of Bell v. Lever Bros and Sol v. Butcher. The concept of mistake in equity was considered both before and after Bell v. Lever Bros. Lord Phillips Mister concluded that it was impossible to reconcile the two cases. Bell v. Lever Bros prevailed, Sol v. Butcher was disapproved. The effect of this decision has yet to be determined, and the question of whether or not there is a separate doctrine of mistake in equity has an uncertain answer. And just like this, you made it to the end of our marathon session on contractual problems. Check out the playlist on your screen for our other long lectures and click the like button so more people can benefit. Thank you for listening and see you next time.